If a deal doesn't close as planned, the buyer isn't automatically entitled to the refund of their escrow deposit. And if the matter isn't handled properly, those funds can be tied up for months or even years. Today's tip will help you avoid the two most common mistakes that lead to an escrow deposit dispute between the parties. Be sure to listen to the end to find out how staking a claim to the deposit funds can backfire if your reasoning isn't supported by the terms of the contract. An escrow deposit is the money put up by the buyer at the start of the transaction as a showing of their good faith in proceeding with the purchase. Most of the time, the title company handling the transaction holds the funds. However, in counties like Palm Beach, where the seller chooses the title company and the buyer didn't have a say in that decision, the buyer may opt to have their own attorney hold the funds in their firm's trust account. The first mistake that can lead to an escrow deposit dispute is not tracking the critical deadlines under the sale and purchase contract. As soon as both buyer and seller sign the contract and all parties are provided with a copy of it, we have our effective date that the deadlines are calculated using. You'll count the number of days for things like when the buyer has to make the escrow deposit, when the right to cancel under the inspection period ends, and when the loan approval is due from the lender. It's a best practice to circulate these deadlines in writing so everyone is on the same page. And the second mistake is oversimplifying the provisions that govern contingencies and assuming that a denial letter equates to the right to cancel the contract. Yes, the contract may be contingent upon financing or the buyer's approval by the homeowner association's board, but there's more to the analysis than whether the buyer was approved or denied. Were the timeframes for putting in the application or any notice provisions complied with? Did the buyer use good faith and make a diligent effort during the application process? Based on the answers to these questions, the seller and the seller's real estate broker may have the right to stake a claim to the buyer's deposit. If competing claims are made by the buyer and the seller, an escrow agent will not release the funds to either side. Some escrow agents will simply hold on to the funds until they're presented with a release signed by all parties or a court order determining the rights of the parties, and others are more proactive and file an interpleader lawsuit with the court. If the parties' escrow deposit dispute ends up in court, either due to their actions or the actions of the escrow agent, each side should consult with an attorney who can go over the terms of the contract that give them a basis to stake a claim to the deposit, as well as the prevailing party attorney's fees and costs provision, which appears in the widely used Florida as-is contract. This calls for the losing party to pay the fees and costs of the prevailing party in the litigation, so an unfounded claim can backfire. If you'd like to have an attorney involved in your sale or purchase, send a text to 561-225-2676 to set up a time to speak with me.